And to that end, let's talk a little bit about the President's executive action on immigration for a minute. I'm referring here to the executive action announced in November of 2014. Now, before the President took that particular executive action, some 22 times prior to that, the President disclaimed any legal authority to regularize the status of individuals, immigrants, here unlawfully. Then came along an opinion from the Office of Legal Counsel, part of the Department of Justice, explaining why a combination of maximally exercised prosecutorial discretion and some strained inferences from cases made it legal for the President of the United States not only to refuse to carry out the immigration laws against entire broad categories of individuals, but also to affirmatively issue work permits to individuals that Congress had deemed ineligible for work permits. Now, I'm going to ask you about that opinion in a minute, but I just want to review the landscape for a minute. When Ms. Lynch came before our committee for her confirmation hearing just a few weeks ago, she testified that she had found that OLC opinion reasonable and indeed, I think, made clear enough that she thought it was correct. Since then, since that hearing was held a few weeks ago, there is something significant that has changed in that a federal district court in Texas, the U.S. District Court for the Southern District of Texas, issued a lengthy opinion in the context of a preliminary injunction, rejecting the OLC's analysis and imposing an injunction against the President's action. Now, the Department, of course, is now fighting that injunction, and we all have to wait and see how the Fifth Circuit resolves that dispute. But I want to ask you, are you familiar more or less with that district court opinion, or at least what it does? And in light of the opinion, in light of its findings, its conclusions, and its analysis, do you think reasonable minds can at least differ as to whether the President's conclusions were lawful?
Yes. Well, thank you for raising this issue, Senator. And this is obviously an issue on which people have very strongly held views. And I think that's certainly very understandable. And it is an issue on which reasonable people can disagree. The fact of the matter is, as you have pointed out, this matter is in the courts now. And as everybody here knows, the Texas District Court ruled, and the Department of Justice is going to abide by that ruling, not just in Texas, but across the country, unless and until a higher court reaches a different decision. And so this issue is now in the courts to be resolved, and we will observe that ruling, whatever it turns out to be. Okay.
I appreciate hearing from you that this is an issue on which reasonable minds can reach different conclusions. And have you read the Office of Legal Counsel memorandum that I'm describing?
I have, yes. I'm generally familiar with it, Senator.
And I know you weren't in your current position. You weren't serving as the acting Deputy Attorney General at the time that was issued. But have you since formed your own legal opinion as to whether the legal analysis in that opinion was correct?
As you noted, Senator, since mid-January, I've been serving as the acting Deputy Attorney General and of the Department of Justice. And the Department of Justice is now currently involved in litigation on precisely this matter. And as the acting Deputy Attorney General, it's really not appropriate for me to be giving my personal opinion on any matter in which the Department is involved in pending litigation, which would include this matter as well. The Department's position is set forth in the pleadings, and I stand by those pleadings.
Are there limits to prosecution?